Hi, everyone on the call. Welcome today to the webinar. My name is Alexandra, and I'm the Director of Education here at the American Apartment Owners Association. I am so thrilled to have Ashlee and Adam back for the third time to talk about California law. They are from Brewer Offord Pedersen LLP, really in the heart of where tenant-friendly laws exist up north. So they definitely know what they're talking about. Just to tell you a little bit about them, Adam is a senior partner at the firm and a real estate attorney. He has over 8 years of experience as a relentless advocate for real estate brokers, landlords, property managers, and agents. He's a licensed California real estate broker, and he focuses his practice on real estate transactions, non-disclosure disputes, agent responsibilities, close of escrow issues, title disputes. Ashlee is a junior partner and real estate attorney at the firm, and she helps real estate investors, homeowners, landlords, agents, and brokers with issues related to partition actions, unlawful detainers or evictions, duty of care, disclosures, and other real estate legal issues. She's also the 2018 co-chair of the Palo Alto Area Bar Association Real Estate Section, and she also frequently speaks to real estate groups as well. So before we hand this off to Adam and Ashlee, I just want to point out a couple of things. Adam and Ashlee have provided a brief outline of what they're going to be talking about today. You can download that on the right hand of your screen. There's also the actual PowerPoint as well if you find that more helpful. We're going to go through probably about 50 minutes of presentation, and then we're going to follow with a Q&A. There is a box to put in your questions, so input those as you think of them. We'll address them at the end of the presentation. And tomorrow you can expect a recording from us. We're going to email you a recording, so if you miss anything, don't worry about it. You'll get it tomorrow as well with the handouts and a message from Ashlee and Adam. If you need to contact them, their info will be in there as well. So that all being said, Adam and Ashlee, I hand it off to you. Thank you for coming on again. We're glad to have you.
Thanks for having us. Hope to do more of these, and I think this starts a series of leases in general, and we wanted to just do one on drafting because this is really where a lot of the issues arise, and people don't realize that. And so you really want to take a lot of care in the beginning, and we're going to talk about that and things to consider. So with that, I'm Ashlee Gonzales, and this is Adam Pedersen, and he'll get us kicked off.
All right, as Ashlee said, my name is Adam Pedersen. I'm an attorney here at Brewer Offord Pedersen, and today we're going to be talking about leases. I'll note that when we were introduced, it was made known that this is the third time we've been giving one of these webinars, and you know what they say about the third time, it is the charm. So if you've been disappointed about the poor performance in the past, get ready because this is the third one. We're going to nail it this time. But first, our disclaimer, as always, basically, know that what we're talking about today is general and the law is very specific. So if you've got questions, if you've got concerns, consult with your attorney or give us a call and we can give you advice specific to your situation. But please don't make specific decisions based on the general information that we're going to impart today. So like Ashlee said, we're talking about California leases and how to make a strong lease. A landlord-tenant relationship is born out of contract, and so it's governed by not only the law, state law, judicial law, but also the contract itself plays a very, very large role in defining what the parties' relationship is. And so we wanted to start the conversation off with a discussion of whether or not to use a form lease or to do it yourself.
Right.
And by that, I mean drafting a lease from the ground up, from scratch. Ashlee, you deal a lot with our landlord-tenant clients. What do you think the percentages are, at least in your experience, form versus DIY?
Well, you can talk about reality or what my hopes are typically. When we get a client in, a landlord, property manager, they telling us they want to evict the tenant, they're having an issue, the tenant is trashing the property. One of the first things that I do is look at the lease, and I would say it's about 50-50, surprisingly. We usually get the CAR form lease, the California Association of Realtors. Sometimes there's NOLO, self-help websites online, LegalZoom. And then sometimes landlords are crafty and they draft it themselves. And those are typically the worst ones just because they don't have certain clauses. But I would say it's about 50-50 between what I would prefer and what they do.
Yeah, I would say that that's probably consistent with my experience as well. And so we'll begin just by going through some considerations you may want to think about when you're deciding between whether or not you want to go with a form lease or a lease that's pre-existing that you can kind of customize to your own needs, or just building one from the ground up. So I've kind of ticked through some things here that I've noticed in practice. I'll go through those, and then Ashlee, I invite you to kind of give your feedback as to what you think might be appropriate to consider when deciding whether or not to do your own lease. And so size and scope of your organization. What I mean by that is typically if you are the owner of, maybe one small complex or a couple of duplexes, probably you're going to be looking at a form lease just because your organizational size probably doesn't warrant the investment in your own lease. Conversely, if you own a bunch of properties, if you've got a lot of units under contract, then you're going to want to go maybe with your own lease because maybe your organization has special needs and you've got the resources to put into that. So that kind of dovetails into the second point, which is access to cost-effective and efficient legal strategies. To make a good lease, it's going to be expensive. If it's not expensive, look out. You're probably not getting a very good product. It's not easy to do. A lot of the forms have been years in the development. And so to replicate that, you want to make sure you're going to somebody who knows what they're doing and can do it efficiently, like us. Not to besmirch others that maybe don't practice a lot of real estate law, but actually I think you'd agree that this is an area where you might get non-real estate practitioners feeling like they can toss their hat in the ring, and it might not be the best idea.
Yeah, I've had landlords, property managers send me a template lease from CAR, and what they don't realize is it's a PDF they've saved 5 years ago, and on the bottom it says it was last updated 2008, whatever the year they decide to do that. The problem with that is every year CAR meets and they change the law and they change their forms, and so just that alone, being current and up to date with the forms, is a major benefit of using someone that has access to those, because a lot of times you may have an accurate lease or a good form lease, but they become outdated pretty quickly. Right, and that kind of dovetails with my last consideration here is maintenance, and that's something that you're going to want to factor into when making this decision, is that it's not a one-time sunk cost. You're going to need to spend additional money and time on this if you do your own documents, having them updated by your relevant legal professionals or other professionals to make sure that they are adequate and up to date. The laws are changing, and so that needs to be done on a regular basis. Right. Ashlee's already kind of ticked through some of the forms available that are out there. I think we all know about the CAR, Association of Realtors form, which frankly is a form that I've used myself. I've recommended clients use it. Yeah. I think it's generally speaking a good form. PRDS, that's a local thing up here in the north. I'd say probably Bay Area specific, right? Peninsula. Yeah, and so that's going to be less common. Some of you may not have had any contact with that. Just know that it's very similar to the CAR form, in as much as it's promulgated by a local association of realtors here in the area. Yeah. Ashlee also mentioned NOLO, LegalZoom, other third-party providers. So there's lots of products out there. Definitely, though, I think you're going to want to pick a bigger name provider, wouldn't you say? Yeah, I would almost always say that, and you really get what you pay for. Most of the time, NOLO and LegalZoom are either nominally priced or free. You want to be careful of that. You don't know who's drafting it. It could be as unstable as Wikipedia, where you can have a layperson providing forms, leases for landlords.com, some random web address, and you may think you got a good deal in a free form, but really you're digging a hole for yourself. So I would say I almost always recommend CAR, and we can get into more detail on that, but that's usually the staple in my book. Right, and Ashlee raises a good point. Make sure that if you go with a form lease, that you do pick a vendor that's active and reputable, and do some research as to what they do
to develop the form and maintain it. Again, going back to the CAR form lease, I know for a fact there's a forms panel that is staffed and regularly changes with folks who are active. Some of those panelists are attorneys, others are real estate professionals. And there's an active process by which these forms, not just the lease agreement, but others, are looked at, updated, and evaluated. And so do they always get it 100% right? Well, I think any practitioner can look at any form, pick it apart, and find things that they would change. But, in general, again, you're going to get a better product if it's actively updated and maintained.
And another benefit with CAR is that they're typically landlord friendly, in my opinion. And so you have to know who you're drafting for. So if you're drafting for your client or you're the landlord, you want to try to push the envelope a little bit and have the lease on your side. There's no reason why you can't advocate for one side or the other. So I think it does have some benefits for the landlord.
So DIY versus forms, we've already kind of touched on some of these issues already, but these are just some of the common pitfalls that I see on both sides, when you're making the decision. The first goes to, I think, who's doing the drafting and whether or not you want to build your own. The assumption of simplicity. People Google residential lease and they get information. They get templates that are free. They cut and paste into a Word document. And it all seems pretty straightforward, and in certain ways, I guess it is on some level, but there are complexities to it, and just assuming that it's going to be this basic lease is I think, a mistake, and so you end up having a lease that's really inadequate.
Right.
Even if the terms in the lease are enforceable and do govern some of the relationship, it fails to go into the depth that I think is required to make a strong lease.
I agree. I mean, bottom line, if you had a lease that said, this is the landlord, this is the tenant, the term, and the rent, arguably we have an enforceable contract, but you're forgetting so many terms that really control and limit disputes. A good example I've seen in the lease that's changed the attorney fee provision being limited to $1,000. That's just one little clause that's in a form lease that can save you as the landlord, property manager, or the tenant even substantial fees, and actually discourages disputes, which is what we're all hoping to do. But there's a lot of clauses that come in forms that protect one side or the other.
It actually raises a good point about that update to the CAR form capping fees. I'm actually going to go ahead and table that for a discussion later. I just added it to the outline here to kind of address in our pitfalls in lease drafting at the end, because I think that she's raised a very good point that certainly warrants further discussion and is a great example of how something can appear simple, but at the end of the day, it really has some complexity to it. The other three all really deal with legal compliance. So legal compliance, changing laws or shifting legal landscape, and local ordinances, including rent control.
Yeah.
So, especially if you are the owner of multiple complexes or multiple units in differing jurisdictions, and by that I mean different cities or different counties, you may want to be really careful about who's doing your drafting and how you're drafting it, because if you either DIY or with a form lease, this could be an issue. So both DIY and forms fall a little bit short in this area, because you're going to need to tailor the agreement to the area that you're in.
Right, I agree. Next, just some of the basic requirements. We've gotten to pitfalls and overall, where do you start? And so now we want to get into a little bit more detail, and Adam can get us started with that.
Yeah, I'm going to just kind of check through the basic things that a lease needs to have. And Ashlee's kind of touched on that before. The basic requirements are pretty straightforward, but we'll run through them to make sure that everybody knows what they are. One sounds kind of simple, is designate the parties, right? You want to know who is the lessor and who's the landlord, and who is the tenant.
Right.
And so it's pretty easy when we talk about, an individual renting a property to another individual. Where it gets a little bit more ambiguous is where you have potentially on the landlord side management involved, and on the tenant side, what if you have a corporate tenant, or same is true for the landlord, what if you have a corporate landlord?
Right.
That's where we go to the other thing. Parties must be identifiable. So it needs to be, stated in a way that you can tell who is the landlord, who is the lessor, and who is the lessee. So it's got to have some minimum level of clarity.
I agree.
Legal capacity to contract. Actually, do you want to touch a little bit on what that is? Is that people might not necessarily know about that.
Yeah, so you have to make sure that the person's able to enter into a contract. This
Mm-hmm.
applies to minors. There's actually a section on the car form lease where you have the tenants, and those are typically the parents
Mm-hmm.
if the family has children. And one thing I really recommend, if they don't have capacity to contract, you still list them as an occupant. And I
Mm-hmm.
believe it's section 2 or 3 of the lease. Even though they're not a legal tenant, you still list them as an occupant. I think, especially in the Bay Area and probably down south, people are living together more and more, family members. So even if the tenants have minor children who may not have capacity to contract, you still want to list them on the lease. I think it's super important. That way you know who's in your unit. And if they want to add anyone else, that's outside the lease and you would have to do an amendment. But
Right.
that's where I see the biggest importance.
Yeah, minors is certainly a legal capacity issue. That's sort of one of the most common you come up against. There's other legal capacity issues as well. For example, if someone is not of sound mind, that's certainly less common.
Yeah.
And frankly can be very difficult to evaluate if someone's coming to rent a unit from you.
It's hard to tell.
You may not know. There may be situations where it's obvious, if someone clearly is presenting as not capable of really understanding the process, that might be a big red flag that there could be capacity issues. Another sort of related area is authority. And authority, we really mean authority in the legal sense. And this is, I think, most relevant to what I'll call representational agreements, or agreements where you have someone signing on behalf of somebody else. Typically, this comes up in the realm of like a corporate landlord or an LLC landlord. Obviously, it's an entity. It's going to have somebody sign on its behalf. So there's always a question: is that person authorized to bind the company? So that's something you want to ensure when you enter into the agreement. Also important on the tenant side, if you're renting to a company, I've actually seen this here in our area in the peninsula. It's kind of common because you'll have tech companies or startups, and it's expensive to live here. And so one of the benefits they might endeavor to offer is to secure rental housing for employees they're trying to woo. And so you want to make sure that you're comfortable contracting with that entity, both that the entity's sound and solvent, but also that the person signing the document has actually been authorized by the entity to do that. So that's an authority issue that you're going to want to make sure you clear up.
Next, the description of the premises. I know this is a little inherent and obvious, but sometimes landlords, especially in the area, they have a granny unit or even a unit in their home where they rent out, say, a bedroom or a guest bedroom. It happens all the time. I don't particularly recommend the landlord cohabitating with the tenant. It just never turns out great. But if you're going to do that, this is an example where you must convey a specific estate. And so if they're going to be in bedroom 2 or it's labeled in the house or something like that, make sure you're very specific about what the tenant is renting, and really you can customize the form if it's bedroom 2 or the upstairs portion of the property, put that, but make sure the parties understand what they're renting and the property is specific.
Right. Classic example could be where you got a property, let's say, we'll look both at single family and multifamily. So single family home, you're going to rent out the home, but you want to keep the freestanding outbuilding or garage as storage space for yourself. Well, obviously you're going to want to make sure that gets in writing into the lease. Otherwise, it could be assumed that was conveyed as part of the estate that was leased out. Same is true with multifamily. It's probably less of an issue there, but certainly describe what exactly is being rented, what access is going to be given to common areas, and when, and all those other limitations should be spelled out in the lease. As far as the other two remaining parts of it, we included this in the description of the premises part. These are a little bit more academic points of law, I'd say, but they do come up from time to time, and it's, I think, important to know when you are making the lease to understand sort of the legal fundamentals of it, which is that the lease is designed to convey an estate, giving the tenant exclusive possession over the premises that are being leased. In law school, we often talk about property as a bundle of sticks. I'm sure Ashlee's laughing a little bit because she's heard this before, but every stick being, an associated property right. Well, when you enter into a lease, you're taking some of those sticks, including possession, which is the most important stick we're talking about, and giving that over to the tenant. And in
Right.
giving over to the tenant, you don't keep it, right? It's not your stick anymore. It's now the tenant's stick. You have ceded possession exclusively to your own exclusion to the tenant. And that can be difficult sometimes for more novice or perhaps, I hate to say maybe smaller operators to understand that it is not, on some level, it's not your property anymore.
No.
You have leased it over to them and it is now theirs.
You're on title, but you don't have possession.
Right, and so, yeah, the title is a stick that you get to keep, but possession is not. So it comes up from time to time, and so just be careful when you do that, and make sure that you're conveying them to them an exclusive estate.
Okay, additional requirements. One of the biggest things that you need to include is the consideration. And in leases, that's rent paid. Typically, number one, you want to put the amount of rent. I almost always see it paid monthly. There's some leases in the Bay Area where it's a unique property where they may pay a year in advance, but I don't really recommend that. So usually you want to put the amount of rent paid, when it's paid, how it's paid, all of that, and then also the security deposit. One of the bigger things we branched down below we want to talk about, because we've had a lot of questions come in with Zelle and Venmo and all these things that come up with electronic transfer, and landlords asking, should we use this? Can we use it? What's the risk? What's the benefits? And one of the biggest issues that you have to consider if you're a property manager and you're accepting rent, or the landlord, is when you serve 30 or 60-day notice to quit. With these, one of the biggest things I advise clients on is that at the termination of that notice period, if you accept rent, you restart the lease, it turns into a periodic tenancy, and that notice is cured. So one of the biggest things landlords ask is, okay, so if the tenant tries to transfer me money after that notice period, does that cure the notice? Well, actually, the answer is no, but I think Adam can explain what courts, how they feel about that and what to do.
Yeah, typically in the case that Ashley's talking about, where let's say you have the ending of a fixed term lease, a 1-year lease, most common, and the lease is ended, it's expired, and the tenant tenders to you payment electronically of rent after the expiry of the lease. As Ashlee said, that can give rise to a periodic tenancy. Now, what the courts have said, though, with respect to electronic payments, is that you can reject that payment, that the tenant cannot force you to accept that rent and thus create a periodic tenancy without you actually accepting the rent. And so the case decisions that I've seen have said, well, in the case of this specific fact pattern where you've got an ending fixed term lease and someone's trying to pay rent electronically to create a new month-to-month agreement, you can reject that payment and avoid a month-to-month agreement, even though it may have hit your account.
Usually has to be as soon as possible. So
you don't want to sit on it. The longer you sit on it, the more it looks like you took the money and accepted it and made a new agreement.
Yeah, don't wait a month. Usually a day or two, you transfer
Definitely
back.
not a month.
But there is some leniency there.
Yeah, it's not immediate. Yeah, I think the case that I'm thinking of dealt with like a 2 to 3 day period where it was returned. Now the court didn't say that was a limit of any kind, but I think it's pretty good guidance as to
you know by then if you got the money and then the time to transfer it back. I think it's all a reasonableness standard, like with most things in the law. So as long as you're reasonable in returning the money, you'll be okay. So that's just one thing we really want to note. If you want to put in your lease, you want electronic payment, which is totally fine. That's one risk that you don't really have to worry about.
And then one other special caveat that I think I would raise in comparison to a 30 or 60-day notice, which we've focused on previously, is in the event of a 3-day notice. Well, if you accept electronic payments and your tenant fails to pay rent, so you serve a typical 3-day pay or quit notice, the tenant can pay using electronic payment and cut off that 3-day notice if you accept electronic payments. Now, that's going to vitiate that 3-day notice, and therefore you're not going to be able to evict on those grounds. So you may want to not do that for that reason. However, it's also important to note that no matter how you accept payment, the tenant has a right to cure the arrearage in the rent, to cure that back rent within those 3 days, whether it's a physical check, cash, electronic. So you're providing them potentially another avenue to make that payment, but it really doesn't change the law in any real way, because they, again, are entitled to cure that arrearage in those 3 days. That's the purpose of the notice.
Correct. So next, additional terms. Number 1, term or duration of the lease. This is super important. The most common I see is 1 year, and you actually want to look at whatever county or city you're located in, because they've actually been changing the laws. In our area, there's a Mountain View ordinance and some other cities where they're actually requiring a 1-year term to be offered to the tenant. And so that's pretty substantial. If you don't comply with that, there's penalties. So you want to be really up to date on the law and consider what's the best duration. Usually a year, I think, is reasonable, because you have a tenant in there for a set amount of time, and you're guaranteed rent for that time. A month to month is usually a little bit riskier, but it could benefit both sides depending on the situation. But just make sure you look at your local ordinances, because sometimes they require 1 year.
Yeah, and I would just say, this is a point I think that a lot of landlords maybe don't think about when they enter into a lease. And as Ashlee said, the general preference in the industry seems to be for a 1-year lease. And I understand why that is. I mean, turnover is time consuming and expensive. We want to have some guarantee of payment, some level of commitment on the part of the tenant to be in the property for a while. But, depending on what your organizational needs are, I always tell people to consider whether or not a month to month might make more sense. Because the reality of it is if your tenant goes broke and can't pay for the unit anymore, and they've got a 1-year lease, your ability to collect that balance of that lease from that tenant is going to be really limited for lots of different reasons, economic and legal, some of which are probably outside the scope of today, but it's an uphill battle, as I think most people know. So the sense of security provided by the 1-year lease might be a little bit of a false sense of security. And a month to month allows for, generally speaking, easier removal of the tenant if you have problems, because you can do a 30 or 60-day notice in many jurisdictions without cause and remove the tenant. And it'll eliminate a lot of other issues, for example, habitability as a defense that we often see when you're trying to evict on, for example, a 3-day notice in the middle of a 1-year lease. Now, there's a lot more 5 points to it than that. I could talk a lot about that, but
all day,
just know that, 1-year terms aren't necessarily the panacea that they are purported to be.
And if you're in a competitive rental market, month to month might be better, because if rents are going up, if you have people like around here in the tech industry that are moving in and out constantly, you might be able to actually collect a higher rent amount if you have renewal. While it may cost you a little bit more initially to get that renewal process nailed down, you can actually keep the rent competitive compared to leaving it the same for a whole year. And next, Adam will talk to us a little bit about intent. I think this is a big one that people don't really consider.
Yeah, and this is sort of an interesting point. And the parties must have an intent to create a lease. And so why have I included this in there? Well, I'm just flagging a potential issue, especially given the expense of the real estate market that we're in here on the peninsula. People are coming up with lots of creative ways to try to get into ownership and lease options. And I'm using that term in a very broad sense. Any type of rent to own or lease option type agreements are becoming more popular. And there can be problems with whether or not those agreements actually envision a true tenancy, landlord-tenant relationship, or whether or not it's something different. And so if it's something different, both the rules regarding the contractual interpretation of that document, whether it's a lease or not a lease, change. So if you are going to enter into an agreement that has that sort of rent to own or lease to own type component, you probably want to seek special advice at that point, because it really is going to change the dynamic of how that transaction needs to look, including invoking a lot of different disclosure rules that aren't involved in standard lease transactions.
Absolutely.
So you're going to want to make sure that you deal with that. And so another tip that I have there is, when you put the rental packet together, the lease together, make sure your lease either identifies, or an addendum, which Ashlee will talk about, that the application itself is part of the lease. And so why do we advise to do that? Well, I have seen many instances where, surprise, surprise, a tenant has been less than forthcoming about their qualifications for a certain unit, or their rental history, or their income, or whether they've been evicted before. So, you know, you rely on that in entering into the lease. That's formed part of the reason why you lease to them. So you want to integrate that into your lease agreement. So if you find out that there's been misinformation provided, you could potentially use that as a basis to evict later on.
And then just make sure it's signed and delivered to all parties. If a certain tenant doesn't sign, if there's multiple tenants on the lease, make sure you get everyone's agreement so you have a fully enforceable contract.
Right. You want all parties to sign, and you want delivery to all parties, and not only because that is clearly the best practice, but it's also required by California law, which we'll talk about now. So the next big area of making a strong lease agreement is disclosures and required information.
And this is your sweet spot,
right?
Essentially.
Yeah, these are issues where if you don't address them up front, they could not only create liability for you as a landlord later on, but could also go to the enforceability of the lease agreement itself. So California law requires that the lease refer or provide the contact information for any manager or owner, and the contact information for the person who will receive the rent and the form of payment. And so that needs to be dealt with in the lease if it's a written lease, and a copy under state law must be delivered within 15 days of the parties signing the agreement. So if it's written, they've got to get a copy of the lease, and the lease has to contain that information. If it's an oral agreement, which is fine, you can have an oral lease. There are some limitations on what can be an oral lease. For example, no oral leases longer than 1 year. But in any event, oral leases are fine. Particularly oral month-to-month leases would be the most common. But you're going to want to issue a separate letter that has this contact information in it, again, within 15 days. And that's what the statute says. So a few other things that need to be in there. If there's not separate gas and electricity meters for the property, that needs to be identified. If water service is going to be billed separately from the rent, that needs to be discussed in the lease. The landlord, from a disclosure standpoint, needs to disclose if there's any known carcinogens on the property. You know, there's not usually, but this is kind of where you get those warnings that are on apartment buildings that say, you know, this premises contain so on and so forth, substances. That's where this comes from. Limited to landlords who employ 10 or more persons, so larger landlords. Whether or not you have an intention to report negative credit, okay, so whether or not you'll be reporting to credit agencies about this tenancy. Whether or not any application has been made to demolish the structure.
It's pretty important.
You might want to know that. It seems like kind of a weird thing, but it comes up often when you have, say, for example, I think it's more common for your smaller operators again, but you know, let's say I buy a 4-unit property and I intend to at some point maybe turn it back into 1 unit and live in it as a large house. Well, I may have made applications to the city to do that, but I know it's going to take a long time. I've got to do all the development work. I've got to do all the planning.
It takes a long time.
So I rent it out in the interim, right? And so what happens then when the tenant finds out that I've applied for this and I've not disclosed it? They're going to be upset, and they're going to feel like they've been blindsided by the fact that this may not be their dwelling for an extended period of time.
And they may have an argument for if they have to move and pay higher rent, you to cover that. It's actually pretty substantial.
Right. So if you've got development plans or things like that, just disclose them as part of the lease, and that takes care of it. Location of ordinance. Now, actually, I have to say with some chagrin that this is a typo. It's not location of ordinance. It's location of ordinance, which is military ordinance, which is explosive materials and things like that. Not relevant for a lot of landlords, but it is a disclosure requirement. If you are renting a property that is located near military installations or old military installations, just, you know, some in Southern California probably have a lot more experience with this than maybe we up here north, or Monterey area perhaps, then you're going to want to make that disclosure. Pest control service, this is pretty common. Most landlords are going to have regular pest control service. There are disclosure requirements relevant to that.
It's if they have dogs or small children, they need to know that someone's going to be coming by bi-weekly, monthly. The last thing you want is someone's dog getting sick or baby, and they didn't know when those periodic visits were. That could be a really big mess. Same with mold. I think that This is inherent in any time you sell or rent. It needs to be disclosed, but only if you know about it. That's a big thing I like to tell our landlords and property managers. You're not required to necessarily go and have a full inspection and hire a vendor, but if you're aware that there is mold, let the tenant know. And then that's just a big one. And then also, we get a lot of questions about the death in the property. Same as if you sell it, if there's a death within 3 years, you need to disclose that. There's some exceptions to that, prior occupants with HIV. Also, an exception to the 3-year rule is that if the tenant or tenants ask if there's been a death on the property, even if it's more than 3 years, you have to disclose that. You have to be honest. So number one, you could look at it as a statutory requirement, 3 years or less. If they ask, it's wide open. So those are really important.
Yeah, and we get this question a lot with respect to death. So to clarify the exception and the honest response to direct inquiries, let's say you're selling a property and somebody died in the property 4 years ago. So you're safe, you're outside of the disclosure for leasing purposes and sale purposes. So you need not make any disclosure. But the potential lessee or buyer comes up to you and says, hey, has anybody died in this property that you're aware of? You got to say yes.
Yep.
You've got to be honest about what you know. The statute does not shield you from disclosing honestly to direct inquiries.
Yeah. Next, you want to talk about lead-based paint. This is a box in the car form that you check, which administers another form to fill out. That's another reason why I like the car forms, but you can talk a little bit about pre-1978 properties.
Yeah, so what Ashley's saying is great advice. I mean, a lot of the form sets are produced by software, like the CAR form set, and so when you check certain boxes or make disclosures, it auto-populates your form set with additional disclosure documents like lead-based paint that help you meet that obligation. Again, so it's a good reason to go with a vendor who's done this before and can provide you that support. Because in any property built prior to 1978, you're going to need to disclose about the risk of lead-based paint. And this is regardless of whether or not you know about any lead-based paint in there. There might not be any, but you still have to give the disclosure form. I've seen clients who don't do this. It can expose clients to risk, including by the EPA. The EPA could fine you potentially as the landlord if you don't make this disclosure.
Yeah, and it's important. We actually have recent clients come in where tenants bring claims against the landlord, and it's taken pretty seriously, especially in California, as was mentioned in the beginning, is becoming more and more tenant friendly. If you don't do these minimum disclosures, it's not taken lightly for sure. Next, bed bugs. This is a new disclosure, relatively new. If you go to our website, www.brewerfirm.com, and you just search bed bugs, we have a little search bar. I drafted the form that is now required to be provided to tenants no matter what, even if there isn't any bed bugs, you're not aware of that. You have to provide the form. I actually did that. So if you want to pull it and use it, feel free. And that's just another requirement where you actually have to do it no matter what. I've seen a ton of leases come out recently where they've come to us retroactively and they didn't give that form. That's an issue. It's the last thing you want is to give a tenant a defense in any lawsuit or eviction. Next, rent control concerns. I just get in the habit of going online anytime we get a new client and I look at the current rules. They change every year constantly, and they're actually pretty surprisingly, for lack of a better word, controlling. There's actually a bill out right now that is trying to institute a California-wide rent increase cap, and they want to enforce just cause eviction California-wide. We'll see if that passes. It's gotten through the preliminary stages. We could talk about that more if you're interested, but the laws are constantly changing, so make sure you're aware of rent control concerns. Next, you want to talk about government subsidized housing?
Yeah, I throw this in here as part of the disclosures to be made because the language that you're going to need to provide to the tenant in your lease, if you're going to take, government subsidy, most commonly, Section 8 housing, is actually, pretty specific and it can be kind of complicated, and it's different than, your typical lease agreement. So if you're going to be engaged in the rental of units to persons who are receiving government subsidies, you're going to want to make sure that you've been in touch with that governmental entity who's providing the subsidy, and that your lease materials are consistent with whatever their regulations are. And again, like other regulations, they change over time. So you're going to want to make sure that you're keeping up to date on those governmental restrictions and or whatever disclosures they may require in connection with providing subsidized housing. It's a bit of a different game than your standard rental agreement. So if you're going to get involved in that, again, you're going to want to be in touch with those relevant government entities and probably get some specialized legal advice.
Absolutely. And you need to disclose any pending foreclosure or default notice that's been recorded on title. So just make sure you make the tenant aware of that.
This may seem like a strange requirement, but it came out of the fallout really in 2008 is where you kind of see the importance of this requirement.
Right.
Because you had a lot of people who had bought properties as investments, because you could, basically buy investment properties with no qualification, no income, no job, no assets, and they, not surprisingly, couldn't pay for those homes, and yet they were collecting rent on those homes. And the tenants were, of course, understandably upset when they found out their rent was being diverted and not paying the mortgage.
Right, or the property was being bought by the bank, who likely would not upkeep the tenancy. So it's pretty substantial. Next, Addenda and Amendments. I am a big fan of both forms, and we're going to talk about that a little bit, just so you know what we use them for and what we recommend them for. First, Addenda, or multiple will be Addendums. I almost always use at least one addendum for every lease I draft, and that's just because every property is unique. I know you've all heard that saying. It's a legal saying and just in general, but the most common times I use it is when there's going to be pets at the property, there's a pool, or you want to clarify a specific use. For the pool, for example, I had a client where they wanted the tenant to be able to use the pool, and CAR actually has a pool addendum. But when I was researching, the Pool Safety Act actually has, I believe it's 7 requirements in the act, and the landlord has to meet 2 of them. And so what I did with the addendum is I put in what the landlord had done. They had installed surveillance, they've installed a fence, all that stuff. And then if tenant didn't use those things or broke the items or whatever it was, that landlord wasn't responsible under the Pool Safety Act. But that was just something that I added to protect my client, and an example of why the addendums are so important, because if the lease does not talk about it and it crosses your mind, or if the landlord is particular, add it. And just as a note, as a property manager, you may be a broker, licensed broker, and taking those tests. But if you're not a lawyer, you're putting yourself in a tight spot, because you're being required to draft legal language when you're not licensed to do so. So know what you don't know. If you need help drafting those forms, especially the addendums, ask. We do it all the time if you want us to review it. But be careful when you're drafting legal language, because one little word, a shall or a may, Adam knows that, can change the whole lease. So just be careful with that. And as I said, seek counsel if you're unsure or unclear. Next, amendments, same thing. If anything in the lease isn't to the landlord's requirements, go ahead and change it. They have amendments for that specifically. If the lease doesn't talk about it, or if they want to modify a term, anytime that happens. Also, amendments are pretty useful at the conclusion of a term, and you don't want to draft an entire new lease. You can do an amendment where common language says all other terms in the original lease remain the same, except for, and then you could do, the new term is July 25th, 2019 to July 24th, 2020. Rent will be this amount, blah, blah, blah. You want to get that in writing. Any change to the lease or any update, you want to make sure you use the form or amend it in writing. Same caveat I give to addendums is make sure you know what you're doing or you seek help. legal counsel specifically, because if you are changing the lease form, which is drafted by professionals, and you're not a licensed attorney or you don't have a lot of legal knowledge, you could be digging a hole for yourself for sure. Lease modifications, you want to talk about this a little bit?
Sure. Just a point of advice, and,
Yep.
and to keep a strong lease strong as it may be, you're going to want to modify the lease over time. So we recommend that at least yearly you review the lease, or at the conclusion of each term. Obviously, that's a logical break point. Anyway, you're going to want to set in place, especially those of you who have multiple units, you're going to want to have a procedure in place whereby you regularly look at each tenant's lease agreement and make the modifications necessary so that it stays enforceable. Like Ashlee was just talking about, there's several bills before the state legislature, there's many more before local jurisdictions that are going to modify what a tenant, needs to have given to them with the lease, or what disclosures need to be made in the lease, what terms are acceptable and not acceptable. For example, you talked about the Mountain View ordinance earlier, and then the need to offer a 1-year term. And that ordinance also deals with when they go to renew after the ordinance has taken effect, what do they need to be offered, right? And so the game has changed for those landlords. They can't offer the same lease for renewal permissibly because the ordinance makes that offer now impermissible. So you have to pay attention to new laws on the state and local level and modify your lease accordingly. So this is the maintenance issue that we were talking about before, but make those modifications, use the addendums that Ashlee is talking about to do that if it's the most convenient for you, and just make sure you're doing that on a regularly scheduled basis.
Right, and if you're planning on increasing the rent, there's some cities in the area, at least up here, where when you do a certain rent increase, you have to run it by the city. And so I've had clients that had no idea that that was a requirement. Also, if you're going to be increasing the rent, giving notice of increase without doing any modifications, this is why I like the forms. But if you just want to increase the rent and not modify the lease, there's specific requirements for that, with the way it's served, with the way it's written, and what the amount is and how many days notice the tenant has to have. So be careful. And it's just another reason why you should do an amendment or actual lease modification. Common pitfalls, I think this is what you all actually care about, drafting a lease. So we want to go over just some common things that we have clients come in where we think it can be prevented if you take precautionary measures.
Right, these are kind of like practice pointers that we've put together, just thinking about what we see in the office a lot, and kind of pointing them out to you guys so that you can kind of benefit from our on-the-ground experiences to seeing what causes problems for landlords. So I think the first one is sort of obvious to most of you watching, is must not discriminate. I mean, we all know that we can't discriminate in our real estate related activities. When we're leasing out properties to people, we can't discriminate based on race, ethnicity, age, and those types of things. One thing that I will flag is also that includes disability and pets. And I see this, happening to managers of property and property owners, I think a lot of times unintentionally, where they're marketing the property as no pets. There's actually organizations out there that sort of do sting operations on landlords and property managers. And they'll, they'll talk to you about your no pets policy. And they'll usually say something kind of vague like, well, I've got a parrot, and this parrot really helps comfort me because, I've got a lot of anxiety, and when Polly's around, I just feel calm and everything's nice. And the landlord says, genuinely, well, I'm sorry, I can't accommodate Polly. We have a no pets policy. Boom, right on the hook. That's where they get you. And so they haven't said to you, I have a disability and Polly is an emotional support animal, but the law supports the claim that is probably going to run afoul, because you can't forbid somebody from having an emotional support animal in the home. And that is true even if you have a no pets policy, and if it's an emotional support animal or disability related animal like a seeing eye dog. I think that's more obvious to most people. You can't charge a pet deposit for those animals. You can't require a pet addendum for those animals. You've got to treat that tenant as though the animal essentially didn't exist.
Yeah, and the next one, family status, I've actually seen it in action. So it's a real war story, but where you rent to a couple, a young couple, and a year or two into the lease, they get pregnant, they have a child, and I've seen landlords try to evict them based on that. So that would be a clear-cut version of discrimination, but actually another form of discrimination that's more subtle is people that put in the lease no ball playing, no playing in common areas, something with no playing. The court has actually said that is explicitly discriminatory towards people with children, and that won't be taken lightly. Yep. So that's one thing to consider.
Yeah, I had a client once, and it was multiple multifamily, properties that were under common management, and so lots of units. I mean, we're talking probably 100, 150 units involved in this particular dispute, and each complex had a policy of no ball playing in the common area, out in the lawn in between the units, essentially. And the federal government was not too excited about this policy and launched an investigation, and it took a lot of work to unwind it. I didn't see any ill will on the part of the landlord. I think it was probably driven, in response to other tenants' complaints about legitimate concerns about property damage and things like that. But you got to be very careful with those usage restrictions that they don't run afoul, because the federal government does, and state government by extension does, look at those policies as potentially discriminatory against families.
And another one, I see a lot of lease drafters trying to waive statutory rights of the tenant. First one, permissible entry. You want to write this code section down. I have it memorized for a reason because we deal with it so frequently. It's Civil Code Section 1954. You should just look it up and read it for your own benefit, but it actually gives specific reasons on when a landlord can enter, and you rarely ever can increase that. So if the landlord tries to put in the lease, landlord may enter with 2-hour notice to visually inspect the property. That's not going to be permissible. Next one, habitability issues. You can't waive those basic ones. It's actually section 1941.1. Retaliatory eviction, same thing. That could be a whole webinar in and of itself. And then future causes of action, either waiving them or maintaining them by way of the lease. That's just one thing that you want to be careful that you don't waive the tenant's rights. You can't do that.
Yeah, and the main takeaway from these 4 points is that with respect to statutory rights, and this is true not just in real estate, but also in like the employment context when we talk about minimum wage or overtime, things like that, typically you cannot waive those by contract, right? And that's very much true in residential leasing as well.
Yep.
And these are kind of the main statutory rights that tenants assert, the main, I'd say the primary tenant protections that are out there under the law. And so they're not things that can be waived. And usually it comes up where you got a landlord who's been perhaps burned and feels like they were taken advantage of, perhaps rightly. So they feel this way under these laws, and they want to put that in the lease to try to avoid a future conflict or to mitigate the risk of a future conflict. So it's a good idea from a common sense standpoint, but it's not going to be legally enforceable, and it puts the lease at risk. So you just can't do it.
And then last two, after this we'll go to Q&A. You want to talk about this, Adam, the last couple pitfalls that we see? Yeah,
the last 2 points are sort of in the ilk of non-waivable things or other terms that can put the lease at risk. One is automatic extension. So specifically in the context of a residential lease, this is a clause in the lease that may say something like, hey, tenant, if you don't notify me within 30 days of the termination of the lease, it's going to automatically extend for another year.
Yeah.
Now, this isn't so common, I don't think, because a lot of landlords probably aren't comfortable giving that kind of automatic extension, but some may want it. And if that's something you want, it's not necessarily void, but it can be voidable. So that means it can make the lease voidable by the tenant if there's a provision in there. You can do it permissibly. There's some requirements by the statute that I think are a little bit outside of today's scope of discussion, but they have to do with things as detailed as font size in dealing with how you put a provision like this in the contract. So if you want to do that, if that's something that you and the tenant want in the lease, I would suggest you seek legal help as far as putting it in there. I also am not aware off the top of my head as to whether any of the forms that are readily available have this term. Have you ever seen this in any of the
It would
forms?
be something you would do through an addendum.
Yeah,
absolutely.
I think it would be a unique provision, but want to be careful of. And then the last one actually kind of dovetails with the disclosure of the default, which is no waiver of remedies for rent skimming. Now, rent skimming is what we were discussing before, which is you're charging a tenant rent, but the property is in default because you're not paying the mortgage on the property, and so you're taking the rent without paying the mortgage. That's, just to keep it simple, that's illegal under California law. It's called rent skimming. And so you can't have the tenant waive any rights as to rent skimming. Now, you're probably not going to put, you hereby not agree not to sue me for rent skimming in your lease, but it might be something more subtle, like, oh, if the property goes in default and necessitates the eviction of the tenant waives all remedies or rights, right? That's a little bit more vague, but it probably runs afoul of the no waiver of rent skimming. So just something to be aware of.
And now questions. I think our host will provide us questions. So if you have them, send them in now. If you've already sent them in, I think we're going to get to those in this last couple minutes.
Perfect. Thank you guys so much. That was extremely informative. I know I definitely learned a couple of things, and we have had some questions come in, and I think actually several of the questions are along the same line of thought, which is the CAR form better than X, Y, or Z organization? And there's a ton that have been listed there. I think people are concerned now that they're not using the CAR form and that it might not be as good as the organization they've chosen. And correct me if I'm wrong, but your suggestion was to maybe ask that organization that they might be using how often they update it, or the protocol that they go through to update that, because I know you guys know that CAR does update it. So is that what you would suggest for these people who have this similar question?
Yeah, I can start that. I think lawyers, just so you all know, we're creatures of habit. So when a form works for us, we tend to stick with that. Adam and I are both brokers, licensed brokers, and we have access to those forms. Right. So that's part of why we use them, because we have that whole database. But from our experience, very rarely do we have a problem with the form itself. If anything, if it's a layperson drafting it, it's a draftor problem. But just from our experience, we've really had success with the CAR form. And yeah, we're biased, but we really go with what works. I think you can comment on that.
Yeah. I mean, the CAR form is certainly the form set that I have the most experience with. And I know it's readily available to most of the real estate folk we work with, which make it sort of a natural fit. I mean, they probably already are working with those CAR documents in their other transactions or otherwise, so they've got access to it. I know it's promulgated by a reputable organization who keeps it updated and looks at it, on a regular basis. So it's an easy recommend for us. But that is not to say that any other organization's forms are any better or worse than the CAR. It's really about, as you indicated in the question, it's about knowing how did they make the form, how often do they look at it, how does it get updated. You just want to be comfortable with the fact that this is a live document and that somebody's got their eye on it, somebody who's qualified to do that. So I'm fine with any form so long as it's being developed in a professional manner.
Great. And from Eleanor, if a tenant agrees to provide 60 days notice to vacate, but the law says 30 days, can this be enforced?
You want to answer that? So typically it's 30 days, but tenant wants to be able to provide 60.
Yeah, I mean, it's going to depend on what the law says with regard to the standard to be applied. But again, anytime you're making a lease term that's contrary to the statute, you could run into a problem of enforceability, right? Now, certainly there's lots of things that you can modify by agreement with the tenant, and I don't see a problem necessarily with the 60-day notice agreement.
Yeah, I think the biggest thing in this situation, which I'm just running it through my head on what a court would say, I think if you're increasing the notice time, that's likely okay. What you don't want to do is have a tenant decrease their statutory time. So if a tenant wanted to limit it to 14 days notice, I think you're in bigger trouble when you're shortening their time. The more time I've seen, at least with notices, the better. But that would be something the court would decide.
And I'm a pretty practical attorney, so my advice to a client in this situation, if they came to me, I mean, typically, if we're talking about the tenant giving notice to terminate a tenancy, and the lease says, hey, tenant, you're going to give me 60 days. And the tenant comes to me and says, I want to be out in 30. I'm probably going to tell the client, put the property on the market and do what you can to accommodate that. Because typically as a landlord, it's getting rid of the tenant that's the problem. If you've got a tenant who's ready to go and you can get the property into someone else's hands who's going to like it, just do that. It's not worth your time and energy to fight about. Right.
It's a good problem.
Okay, and a question from Bill. Are security cameras permitted in a rental property? Do you need to disclose that?
That's a great question. Most commonly, common areas, yes, they're permitted as long as they're disclosed, but inside the unit, you want to talk about that?
I would not put cameras inside the unit. That's my simple answer to the question.
No,
you're not going to want them in the
reaction.
unit. Yeah, no, I think that's again, that goes back on some level to the bundle of sticks we were talking about, right? You've given up that stick of possession. It's exclusive, and by putting cameras in the unit, you're potentially, if not actually, running afoul of many different potential laws and privacy concerns. But no, common areas are not a problem. Common areas is fine.
You have quiet enjoyment issues here, privacy, and then your intent for the cameras, I think, is the major element. If you have common area cameras, you really can argue that, yeah, I'm looking out for the security of the property. It's usually in the outside areas or places where you see criminal activity. When it's inside, the intent of security goes away, I think, in my opinion, and then it's a privacy issue. So I would avoid interior cameras.
And in fact, you may be required by some arguments to put cameras in the exterior areas if there has been a history of criminal activity or something, and the landlord's on notice of that.
Good point.
So that's definitely something you could consider.
Okay, and from Basuki, for payment by Zelle, I was told by Bank of America that you can cancel the Zelle service by calling the bank, but for other electronic payments, when it's already going to go in the account, how do you reject it? Do you have to just write a check back to your tenant?
I think either way you return the money is efficient, but a lot of times what I suggest my clients do first is they call the bank, and the bank can see the source of the funds and usually just bump it back to that account. They have the ability to do that. They see more than we see. They don't see the account details that it comes from. A lot of times it might just say, Mike Smith transfer, and then the tenant puts a memo and the amount. The bank will actually see wiring information or whatever they used and will bounce it back. The check, that's a good point, is another option. If within a day or two the bank can't figure it out, send the check back. Whether or not the tenant accepts that, you've made the effort to return the rent.
Yeah, the point is, I think, twofold. Number one, just talk to your bank. I mean, the times that it's actually come up in practice for me, that's what the client has done. They've asked the bank to reverse the payment, and however the bank did that, sort of outside of my bailiwick, but the bank does it, and it's happened. I've never really had it go beyond that. And then if you look at the case law on it, it's really just it has to do with whether or not there was an acceptance of the money by the landlord. So is the landlord really accepting the money and creating this new month-to-month or periodic tenancy? And if you refund the money by check, I think that would fit within the idea of, no, I'm not accepting it.
Right.
Okay, and from Mary asking, can you suggest any language for the lease when a tenant does not put the utilities in their name in a timely manner? Can I give them a surcharge for this due to the hassle?
I think the short answer is yes, but more so in the lease, I would recommend a time limit. So say if they have 30 days to switch over the utilities, if they don't do that, technically they're in breach. And so if you wanted to serve a 30-day notice based on the breach of the lease, 30-day notice to perform or whatever was applicable under the lease, you would do that. I think that'd be the best route. And that's just another example. If the lease isn't specific for that and you have concerns about the tenant putting their name on the utilities, put a deadline on there, put a sunset date where if they don't do it by that time, you're going to kick them out. And a lot of times that will motivate them to take action.
Yeah, that seems like a most efficient way to deal with that issue. The lease should provide a deadline for putting the utilities in the name of the tenant. And then if the tenant doesn't do that, it's a breach of the lease, and you can do either a 3-day or a 30-day notice, depending on what your preference is at that point.
Okay, I know that we're a little bit over time, but there are a few more questions. Do you guys mind answering a couple more?
We don't.
No, we don't.
Okay.
We're just going to charge double for that. That's all.
All right, thank you guys. So another question here from Bill. He says that he has a storage garage that he rents out. Does that require a 24-hour notice, or can it be a shorter notice because it's not a house?
You want to answer that? I believe 1954 specifies a dwelling, but I'm not certain.
That's my impression too. And that's about as concrete of an answer I can give off the cuff. I don't believe so, because I think actually it's correct that 1954 has to do with dwellings, but you're also going to want to make sure that you deal with that issue in your storage lease, in your rental agreement, because there could be limitations there. And I would guess that if I dug into it more deeply, there's probably some law that limits the right of access to something reasonable, because you are leasing out the premises. So I don't think you get unfettered ability to go inspect the storage unit. But again, I would want to double check that. I'm not candidly 100% sure.
Right.
Okay, and a couple of questions for the car form. If they're not brokers, how can they access that form? What do you suggest?
Sorry, a little bit of feedback there. You know, you can go to a real estate agent friend or a broker friend if you have one. If you've got a property manager, they are either going to be a licensee, well, they're going to be a licensee of some kind, so they could go to their broker and get it if they don't have access, or they would have access themselves. But yeah, typically you're going to go through somebody who's a member of the Association of Realtors. I also believe that you can purchase the CAR forms from the CAR website. Is that
I'm
right,
almost
Ashlee?
certain, yeah, you can do some kind of subscription.
Mm-hmm.
But again, the only risk to that, I think, would be that you're not licensed and you're drafting them, so you're drafting forms that are meant for licensees. But I'm pretty sure that you can do some kind of subscription.
Mm-hmm.
How much that is, I can't say for sure.
And again, if you do it that route, you're going to make sure that you're going and repurchasing the form or redoing your subscription as needed, because we did have a case the other day where it was a dispute over a lease, and it was the CAR lease, but it was the iteration of the lease from, like 1995 or something like that. Yeah. So this person had been using this form for a long time without updating it.
Yeah.
And is there a CAR form for lease modifications?
There is. There's an amendment form in CAR. There's an addendum. Pretty much anything to do with a lease, they have a form for. I would say amendment is your best bet. Addendum, the way to think about it in your brain, addendum is to add, amendment is to change or amend. So any lease modification, I believe, would come from the amendment form. So all you have to do is search. You could do amendment, space lease, and usually that'll come right up.
Okay, great. And from Patricia, last question here. If you discover that during the tenancy, the tenant lied regarding having a criminal record or drug use, can you use this as grounds for eviction?
It's a complicated question. And the answer to your question is probably yes, but I would need to know more to answer your question. So let me see if I can kind of put the hypothetical into more clear terms. Where a tenant has misrepresented the qualifications that you relied upon in entering into the lease agreement, that generates an argument that you could potentially evict the tenant for that reason, right? And so that's one of the reasons why I recommend that you integrate it into the lease, because that strengthens and solidifies that argument. And so, there'd be a lot more that I would need to know, but yeah, it certainly is an issue. And if you find out whether or not a tenant has misrepresented things in the process of securing the lease agreement, that's, I think, the moment where you really need to reach out and seek legal counsel and say, hey, do I have a basis to evict? And if so, can you help me articulate that? Because it's also going to rely on a lot of other facts that I simply don't have before me, and also where you're at, what your local jurisdiction is there any rent control, that might come into play, and is that going to be a factor, and so on and so forth. So it's kind of a complicated question.
Yeah, and it may be a risk-benefit analysis. If you're a month to month, or if you're close to the end of the lease term anyways, you might just want to wait instead of instituting a legal action.
Mhm.
If you can get them out for, you know, a no cause eviction, sometimes we
Right.
call that, it may just be the road that's easier for you, but I think we would just have to look at the lease, look at where you're at
Mhm.
in the term, and see if there's any easier routes. If not, you know, we'll have to take action.
Right, Ashlee raises a great point. It could take 2 or 3 months for an eviction to play out, especially an eviction of the type that we're talking about now.
Yeah.
If it's a fixed term lease that expires in a month, you know, the juice is not
faster.
worth the squeeze. So
Right.
yeah.
Okay, great. Well, thank you both so much for the time. Honestly, it was very informative, and I'm sure everyone's learning a lot. And I'm getting a lot of thank yous coming in here on the chat. So from everybody and from me, thank you. And for those still on the call, we'll be emailing you the recording tomorrow. You have Adam and Ashlee's info here. I'll send it again. So you all might be getting some questions. Thank you again so much for coming on. We really appreciate it.
It's our pleasure. Thank you for having us.
Yeah, great to be here anytime.
All right. Take care, everyone.